Welcome to businesstraining.com. This is our agenda for the video topic today, Age Discrimination in Employment Act. Please take a moment to review the outline. The Age Discrimination in Employment Act, or ADA, was enacted in 1967 and was passed on to promote the employment in older workers based on ability, not age, and to prevent discrimination as well as to help solve problems that come with an aging workforce. The ADEA applies to employers that are engaged in an industry affecting commerce and that have 20 or more employees that are working each day for 20 or more weeks in the current or preceding year. This includes overseas employees. Independent contractors are not employees within the meaning of the Age Discrimination in Employment Act and are not entitled to protections. The Age Discrimination in Employment Act prohibits employers from refusing to hire a candidate, fire an employee, promote, set wages, or otherwise discriminating against an employee age 40 or older on the basis of age. Employers cannot deny pay or fringe benefits with age as a justification. They cannot classify, segregate, or otherwise limit employees into groups on the basis of age in any way that it unfairly deprives workers of employment opportunities or negatively affects the employee's status. The employer cannot also have statements or specifications in their job announcements or postings that have age preferences or limitations. Most sectors are prohibited from establishing a mandatory retirement age. Mandatory retirement ages may be justified under the argument that certain occupations are too dangerous or require high levels of physical or mental skill, such as airline pilots or military service members. The ADEA does carve out a mandatory retirement exception for bona fide executives or high policy makers, which are executives that are over 65 in high policy-making positions who are entitled to receive a non-forfeitable annual retirement benefit of at least $44,000. As with other discrimination protection acts, employers are not allowed to retaliate against an individual for opposing an employment practice that discriminates based on age for filing an age discrimination charge, testifying, or participating in an investigation or litigation under the ADA. The Age Discrimination in Employment Act also prohibits harassment on the basis of age. Employers are allowed to reduce benefits based on age only if the cost of that reduced benefit to the older workers is the same as the cost of providing full benefits to younger workers. An age limit may be legally specified for a position when age is shown as a bona fide occupational qualification. Employers may also have a bona fide seniority system which is intended to evade the purposes of the ADA, except that no such system shall require or permit the mandatory retirement of any individual because of age. The Age Discrimination in Employment Act authorizes remedies for damages to individuals who have had their ADA rights violated. An individual is required to pre-file a charge with the Equal Employment Opportunity Commission within 180 days after the alleged unlawful practice occurred. The plaintiff may not then file a civil action suit under the ADA until 60 days after the charge alleging the unlawful discrimination has been filed with the EEOC. Age Discrimination in Employment Act violations can include damage remedies of back pay consisting of wages, salary, and fringe benefits that would have been earned during the period of discrimination. Attorneys' fees may also be reimbursed or liquidated damages where willful violation has been found to occur. Compensation damages, such as recovery from pain and suffering, emotional distress, humiliation, or injury to professional reputation, and punitive damages are not awarded under the ADA. Front pay can be awarded to compensate victims for anticipated future losses. And injunctive relief, such as reinstatement and in order to prevent future discrimination, are also common damage remedies under the ADEA. Age discrimination claims are common when there is a reduction in force, particularly of longtime employees. As such, the Older Worker Benefits Protection Act was passed in 1990, amending the Age Discrimination in Employment Act, and prohibits the discrimination in employee benefits. The Older Worker Benefits Protection Act, or OWBPA, sets requirements for voluntary waivers of ADEA claims. A voluntary waiver of ADEA claims may be requested by an employer when they are offering an early retirement program or when implementing a reduction in the workforce, whether voluntary or involuntary. Under the Older Workers Benefits Protection Act, the voluntary waiver of ADEA claims has some requirements. The waiver must be part of an agreement between the individual and the employer and be written in a manner that is assumed and able to be understood by the employee or by the average person eligible to participate. It must specifically refer to the rights and claims that arise under the ADEA and that the individual does not waive the rights or claims that may arise after the date the waiver is executed, as in any future ADEA violations beyond the waiver execution. The waiver must provide that the waiver or rights or claims occurs for the individual only in exchange for the benefits that is in addition to anything of value that the employee is already entitled to. And it must also state that the individual has been advised in writing to consult an attorney prior to executing the agreement. If the incentive or benefit program is offered to just one individual, the waiver must give the individual at least 21 days to review and consider the agreement. If the waiver is offered in connection with an exit incentive or other employment termination benefit program to a group of employees, the waiver must give individuals at least 45 days to consider and review the agreement. The ADEA waiver must also allow a period of at least 7 days following the agreement or non-agreement where the individual may revoke his or her decision. The waiver shall not become effective or enforceable until the revocation period of 7 days has expired. If the waiver is offered in connection to a group of employees, it must provide each employee in the group information so that the employee will understand the group or class of individuals covered by the program, any eligibility factors for the program, any time limits applicable to the program, the job title and wages of all individuals who are eligible for or selected for the program, and the ages of all individuals in the same job classification or organizational unit who are not eligible or selected for the program. This is a requirement to show that there is no age discrimination in place in the decision of voluntary or involuntary reductions in force. If you would like more information on the Age Discrimination in Employment Act or Older Worker Benefits Protection Act, please go to the Department of Labor website at the following link. Thank you once again for your time and attention, and this is businesstraining.com, where you can earn a master's level qualification to make more money.